EWS రిజర్వేషన్లపై సుప్రీంకోర్టు తీర్పు వెలువరించింది. EWS రిజర్వేషన్లను సమర్థిస్తూ సుప్రీంకోర్టు తీర్పునిచ్చింది. ఆర్థికంగా వెనుకబడిన వర్గాలకు 10% రిజర్వేషన్లు సరైనదేనని న్యాయమూర్తులు జస్టిస్ మహేశ్వరి, జస్టిస్ త్రివేది, జస్టిస్ లలిత్తో కూడిన ధర్మాసనం తీర్పునిచ్చింది. సుప్రీంకోర్టు ప్రత్యక్ష ప్రసారం ఇప్పుడు లైవ్ ద్వారా చూద్దాం.
Summary of findings in questions 1 and 3. On question 1, it is held that the state's compelling interest to fulfill the objectives set out in the directive principles through special provisions on the basis of economic criteria is legitimate. That reservation or special provisions have so far been provided in favor of historically disadvantaged communities cannot be the basis for contending that other disadvantaged groups who have not been able to progress due to the ill effects of poverty should remain so, and the special provision should not be made by way of affirmative action. Therefore, the special provisions based on objective economic criteria is per se not violated. However, in answer to question 3, I have highlighted the framework within which it has been introduced by the impugned amendment, excluding backward classes. According to me, this is violative of the basic structure. A universally acknowledged truth is that reservations have been conceived and quotas created through provisions in the Constitution only to offset fundamental, deep-rooted generations of wrongs perpetrated on entire communities and castes. Reservation is designed as a powerful tool to enable equal access and equal opportunity. Introducing the economic basis for reservation as a new criterion is permissible. Yet, the othering of socially and educationally disadvantaged classes, including SCs, SCs, and OBCs, by excluding them from this new reservation on the ground that they enjoy pre-existing benefits, is to heap fresh injustice based on past disability. The exclusionary clause operates in an utterly arbitrary manner. First, it others those subjected to socially questionable and outlawed practices, though they are amongst the poorest sections of the society. Secondly, for the purpose of new reservation, the exclusion operates against socially disadvantaged classes and castes absolutely by confining them within their allotted reservation quotas. Thirdly, it denies the chance of mobility from reserve quota based upon past discrimination to a reservation benefit based only on economic deprivation. The net result of the entire exclusionary principle is Orwellian, so to say, which is that all the poorest are entitled to be considered regardless of their caste or class, yet only those who belong to other classes or caste would be considered, and those from socially disadvantaged classes would be ineligible. Within the narrative of the classification jurisprudence, the differentia or marker distinguishing one person from the other is deprivation alone. The exclusion, however, is not based on deprivation, but social origin or identity. This strikes at the essence of the non-discriminatory rule. Therefore, the total and absolute exclusion of constitutionally recognized backward class of citizens is nothing but discrimination, which reaches to the level of undermining and destroying the equality code, and particularly the principle of non-discrimination. Therefore, on question 3, it is clear that the impugned amendment and the classification it creates is arbitrary, results in hostile discrimination of the poorest segments of society that are socially and educationally backward and are subjected to caste discrimination. For these reasons, Articles 15(6) and 16(6) are struck down and held to be violative of the Equality Code, particularly the principles of non-discrimination and non-exclusion, which form an inextricable part of the basic structure of the Constitution. While this reasoning is sufficient to conclude that Article 16(6) is liable to be struck down, there are additional reasons elaborated in Part 5, due to which this court is compelled to clarify that while the economic criteria per se is permissible in relation to access to public goods under Article 15, the same is not true of Article 16, the goal of which is empowerment through representation of the community. For the above reasons, it is hereby declared that Sections 2 and 3 of the Constitution 103rd Amendment Act 2019, which inserted Clause 6 in Article 15 and Clause 6 in Article 16 respectively, are unconstitutional and void on the ground that they are violative of the basic structure of the Constitution. The writ petitions are consequently disposed of. It would be in order to place my gratitude and appreciation for the valuable assistance rendered by all counsel and all the counsel assisting them